come to order. Members, take your seats. Chair recognizes a quorum. Today, we have 4 bills on our agenda, 637, 1744, 2319, and 167. So, first order of business is minutes of March 19th. Do I have a motion for the March 19th minutes?
So moved.
Chair Liebling moves the March 19th minutes. Any discussion? All in favor, say aye. Aye. All opposed, say no. Motion passes. The minutes of March 19th are approved. The first bill that we have up is Representative Morrison is here. Come on up. And motion on House File 637 of Representative Morrison is that it be recommended to be placed on the General Register. Now, I think I recall there was some discussion about this or questions about it, but you have an A5 amendment, an author's amendment. Is this like a Peace in the Valley amendment, Representative Morrison?
Chair Lesh, that might be a fair way to describe it.
Okay. So does someone move that House File 637 be recommended to be placed in the General Register?
Mr. Chair, I would make that motion.
Okay, then Chair Liebling does that. And then the A5 amendment. Why don't you tell us about the A5 amendment first, Representative Morrison?
Chair Lesh, the A5.
Oh, I'm sorry, there's an A4 also. We'll take them in the order you want to take them, so go ahead, take which one you want.
I think we're just doing the last amendment. Right?
Does last mean A5?
The A5 amendment that was discussed yesterday, and that just removes a section, Chapter 364.
Oh, is that section, section 8?
Yes, that's correct.
Okay.
I'm sorry, it's actually Section 7.
Section 7. I'm trying to piece this together in my mind from the rapid fire emails that everyone in the Capitol is copying me on their emails now. So I think that this was something that I noticed and saw. Chair Scott, did you want to speak to this? You know? Okay. All right. Huh? Well, I don't know. I usually pay pretty close attention to these, so I thought I'd give you the opportunity to weigh in. But it hasn't been moved yet, but I'm going to give you the opportunity to speak to it anyway, Representative Morrison.
As I said, Chair Lesh, the amendment is to strike Section 7 that is regarding Chapter 364 for the licensing boards of chiropractic examiners, medical practice, and nursing. We're just removing that language to simplify the bill.
Okay. So everyone sitting up there is in favor of that, of moving the language to strike Section 7. Is there anyone in the audience who is opposed to the amendment or the motion to strike Section 7? Anyone at all? Okay. All right. Any committee discussion? Well, let's move it first. Oh, Chair Scott.
Yeah, Mr. Chair, I would just ask the testifiers to elaborate on why they're moving that, or why they're removing that.
Okay. Why are you taking it out?
Mr. Chair,
Chair Liebling.
maybe it would be more useful, actually, to have them talk about the bill and then focus on that piece, because it is kind of I don't know if members kind of, know what just should give a general overview of what they're doing and who they are. They haven't even introduced themselves yet, and just a suggestion, Mr. Chair.
We've got 2 competing suggestions. So, I'll defer to the committee on this. Do people want to hear about the amendment, or they want us to go into the whole bill first? You mean north-south? Chair Johnson.
Chair Lesh, I think it might be best to get an understanding of the bill and then understand the reason.
Let's do that then before we move the amendments. Go ahead and introduce yourself for the record and begin your testimony.
Mr. Chair, members, my name is Ruth Martinez. I'm the Executive Director of the Minnesota Board of Medical Practice.
And I'm Shirley Brecken. I'm the Executive Director for the Board of Nursing.
Welcome to the committee, and go ahead.
Mr. Chair, members, the The bill and the amendments that you've seen and referenced and had some emails regarding relate to Chapter 214, a common section of statute to all of the 16 health licensing boards authorizing criminal background checks for the purposes of applications for licensure. And Section 364, which is part of the Criminal Rehabilitation Act, we were seeking initially to gain access to unredacted criminal background check reports for the purpose of reviewing that information in an application process. I think it's fair to say that we have heard some concerns about that modification of Chapter 364, and in the discussion of some of those concerns, that leads to this amendment to remove Section 7, which modifies Chapter 364. We are still very much pushing forward on modifications to Section 214 changes that apply to the health licensing boards. And I can go over those changes for you if you'd like. So House File 637 addresses the section that authorizes criminal background checks for all of the health licensing boards. The bill addresses the common process for authority for criminal background checks and also for imposing temporary suspensions of licenses. We also have done a little bit of a modification to a section of 214 that applies to sharing of data, specifically to criminal history record information. So the revisions are really in follow-up to implementation of criminal background checks across all of the boards. We just completed that implementation on January 1st of 2018 across all of the health licensing boards. And in that process, as we were operationalizing criminal background checks, we realized we needed to make a few adjustments in the language of the law to just allow us to process those criminal background checks reasonably and appropriately for our licensees. So some of those changes will help with issues that applicants sometimes have to complete 2 criminal background checks for the same licensing board to obtain different levels of licensure. So we've modified a section to allow 1 criminal background check with 1 health licensing board for more than 1 level of licensure. It does say that that criminal background check is valid only for 1 year. The modifications also provide clear authority for a board to request a criminal background check from a current licensee for the purpose of participating in a medical, or excuse me, in an interstate licensure compact. And currently this has been an obstacle for the medical licensure compact. And we have a testifier here today who will talk a little bit about that as well. So the problem here has resulted in Minnesota not being able to fully participate in the medical licensure compact, and there are several other professions looking at interstate compacts, so this is significant for several boards. We also have a modification that eliminates duplication by removing a 90-day time frame for submitting fingerprints. Currently, if they don't submit fingerprints within the time frame, they have to pay a second fee, and we just have found that unnecessary. They can't proceed to licensure without completing the fingerprinting process and getting the criminal background check completed. And we've also modified a section to obtain additional sets of prints at cost. Currently, the BCA will process 2 sets of fingerprints for 1 fee, but if the prints are rejected a second time, the applicant has to pay another fee. So we've just brought this in alignment with how the BCA currently addresses those 2 sets of fingerprints. And finally, Chapter 214.10, Subdivision 8, this is the data sharing section of statute. We have explicitly stated that we will not be sharing criminal history record information. And I know that this was very important to the FBI and to member states in interstate compacts as we contemplate how we may or may not exchange information. So we will absolutely be protecting that criminal history record information. And I think Ms. Brecken has some additional comments.
Thank you.
Mr. Chair, members of the committee, there is another revision in Chapter 214 that relates to the temporary suspension provision that the boards have. Currently, if an individual is deemed to be a significant risk of harm to the public, the board has the authority to do a temporary suspension That temporary suspension is imposed, and then the board has 30 days to go to a hearing for the individual. Once that hearing occurs, it goes to the administrative law judge at OAH, and the ALJ has 180 days to respond to the board. Once we get that report back from the ALJ with a recommendation of whether or not to impose discipline, the board must go to hearing within 30 days. The difficulty is that most of the boards meet only every other month or every quarter, and so what has happened, given the timing, is that a special meeting of the board has to occur. And as you know, board members are volunteers, they have real jobs, and sometimes we've been challenged to get a quorum on such a short notice. So we worked with the Chief Administrative Law Judge, Tammy Poost, as well as the original authors of this particular provision. Representative Liebling was one of those individuals, and to increase the maximum timeline from 30 to 60 days between the receipt of the report from the ALJ to final action by the board. However, if the recommendation of the ALJ is not to impose discipline, then we would revert back to the 30 days. So to do it as quickly as possible for the individual so that they can return to unencumbered license. With that, I'd be happy to answer any questions regarding that.
Any questions from members of the committee, testifiers? Chair Scott.
Thank you, Mr. Chair. And I'm just wondering if House Research could kind of give us an idea of what removing Section 8 does to the bill. If it, I'm just concerned that we're not letting anything slide by here as far as endangering the public or anything like that by not making something known about a licensed applicant, I guess.
Well, Mr. Hopkins.
Mr. Chair and members, so Section 7 specified that health-related licensing boards would not exchange criminal history record information. There's already certain provisions dealing with health licensing boards exchanging that kind of information, criminal history record information, in current law. I believe Section 7 would have broadened the exception for health licensing boards. So by removing Section 7, the current exemptions regarding sharing of criminal history information persist, and they don't get any broader. I believe that's correct. The testifiers might want to weigh in on this as well, though.
Yeah.
Chair Scott.
Mr. Chair, thank you. Thank you, Mr. Hopkins. Yeah, and if they could weigh in, that would be helpful. Thank
Okay.
you.
Go ahead,
Mr.
Ms.
Chair,
Bracken.
Representative Scott, the boards were initially seeking authority to, I'll back up a minute. Currently, 364.04 requires or prohibits the BCA from disseminating or distributing information related to charges and arrests. It limits it to criminal convictions. And so what happens is the boards may not have full information at the time of an application for a license. As you know, somebody can be charged and court's pending, and it can go on and on and on. And so the risk is that the boards might license somebody who later on we have to go through the process of removing that license because they have by that time been convicted of the particular offense or charges. I think what's important about that is that the boards really believe that having full information about arrests and charges gives the boards the right information to make a decision about licensure of a healthcare professional who is caring for vulnerable people, sometimes in their homes, without any kind of supervision. But there was, there's been concerns raised about that, and in the interest of moving the bill, we are willing to look, to deal with what we have at this time. Did you want to address
Chair Scott.
All right. Well, thank you, Mr. Chair. And I appreciate that. It does give me concern, because this is the first time I've seen this amendment. It looks like it was posted yesterday afternoon at 3:30 in the afternoon, and which is after deadline, and so this is the first time we're looking at this and trying to get a grasp of what it really actually does in the real world. And I want to make sure that, obviously, we're keeping patients as safe as possible, and that the licensing boards have the information that they need to make the best decision possible. So I just don't want anything to slide under the radar. So thank you, Mr. Chair.
Chair Liebling.
Thank you, Mr. Chair. And, I don't have really strong feelings about it one way or the other, but I mean, it does kind of go back to that issue about arrests and charges are not convictions. And, there is this due process right to be able to have your license. And so it's how do we strike the right balance? And, I appreciate that there could be concerns on both sides. And I don't know who, obviously this section has traveled in the bill up till now. And I don't know, if somebody then is subsequently convicted, I think we heard the testifier say that there would be a process. It's not like it would go unnoticed. And certainly they're getting a background check every year, right? Or, no, I'm sorry, it could be, maybe you'd have to repeat that exactly. But anyway, there is a process if somebody's convicted. It's not like, this means they would never find out. But it just really goes back to that thing of how do we think about arrests? How do we think about charges? And of course, also knowing that arrests and charges are not, in different communities, they could mean different things as well because, let's face it, people of color are arrested more often. They're charged more often. And if you don't even have a conviction, I don't know. So I appreciate your concern, Representative Scott. This is a tough one.
Mr. Chair?
Chair Scott.
Thank you, Mr. Chair. And I'm appreciative of that. I'm very much a person that is in favor of due process. That's kind of the American way. And so I get that. What about stays of adjudication? Because a lot of times those kind of trouble me sometimes because they're almost seen as some sort of a plea bargain. Would we have access to stays of adjudication with this change? I don't know who wants to answer that question.
Can research answer the question? Mr. Johnson?
Mr. Chair, members, the language in 36404 refers to convictions. Convictions is a defined term, and stays of adjudication are generally not considered convictions as defined in the statutes. So, to my knowledge, no, they are not. They do not receive information about stays of adjudication.
Well, Mr. Chair,
Chair Scott.
I just remember the incident with the bus driver in Blaine that had a stay of adjudication, and then he went on to violate a young girl, and so that's why I brought that issue up. And I know Representative Grossel's not here, but I know that's a big deal to him. So that's just one of those things that's kind of concerning to me. But does it leave the boards here with any liability if something like that would slip through the cracks?
Well, Chair Scott, as a person who has both offered and asked for stays of adjudication in court on multiple times, I can tell you that I think there's a general misunderstanding about stays of adjudication. Stays of adjudication are only on the record when your case is so weak as to make the prosecutor think they probably would lose that trial anyway, but at least they can get a little skin in the game by getting some conditions based on a stay of adjudication. A stay of adjudication cannot be given by a judge over the objections of the prosecutor. It's reversible error. So in my understanding of those stays of adjudication, they're extremely weak cases that maybe shouldn't even have brought anyway because the evidence wasn't there. And maybe even in this case with the bus driver, they didn't have the evidence there. If they did have the evidence there and they offered the stay of adjudication, that's a major problem. But I just wanted to put that out there that a lot of times those of us who do criminal law see them as just super weak cases. But you bring up a valid point. If the evidence is there and they didn't do it, that's the prosecutor's fault in a big way. Any other questions? Representative Johnson.
Chair Lesh, and to testifiers. On line 6.26, the repeal statute 214.075 subdivision 8. And that was a requirement by the board to set up a plan between the Commission of Health and Human Services and BCA to do these background checks for when that law was, the initial law was put into effect. I just want to make sure that that plan has been put in place before we repeal the statute.
Mr. Chair, Representative, that was a
Sorry, Ms. Brecken, go ahead.
Mr. Chair, thank you. That was a requirement at the time of enactment, and there was a study that was done between the boards, the BCA, and the Department of Human Services. The intention of it was to look at, right now, the requirement for criminal background checks is for applicants for licensure. It's a one-time at the time of application for licensure. Obviously, we have many licensees that we've had for many years that have not had a criminal background check. And the intent of that study was to look at how could we deal then with that population so that, but it was really contingent upon federal wrap back. And at this time, the BCA does not have authority to do federal wrap back for non-criminal background checks. And so ultimately, the report was filed with the legislature and the legislative library recommending that that happen within the next 5 years since implementation of criminal background checks for applicants.
Chair Johnson.
Chair Lash, so in other words, the plan has been put together following the statute, so it can be repealed now?
Ms. Brecken.
Mr. Chair, Representative, there was not a plan developed because, as I said, the BCA does not have authority to do that federal wrap back. However, we had recent conversation with the superintendent of the BCA, and we're going to enter into those discussions after session.
Chair Johnson.
Chair Lash, I guess I'd have a little bit of problems repealing this because this is the intent of the legislature when this put into effect to make sure that criminal background checks were done the proper way and that there was a plan in place to fulfill that. That was supposed to be completed by, if I remember correctly, January of 17. That plan has not been fulfilled, or that part of the statute has not been fulfilled. I guess I have trouble repealing that part of the statute if they're not fulfilling the statutes that we required.
Ms. Brecken.
Mr. Chair, Representative Johnson, I appreciate that. The intent was not continue to proceed. Actually, if I'm recalling correctly, it was the revisor's office that advised repealing this particular section because it was time limited. It had to be done by the 17th of January, or excuse me, 2017 January. So it was viewed as being no longer in effect.
Chair Lash, I guess if to do anything, I would make sure that it was put a different end date, because this needs to be done, because we do need to do these background checks. They're important. These people that are getting licensed have some responsibilities. We want to make sure we have the people that aren't qualified because of their background not getting licensed. So I think we need to maybe look at changing the end date instead of repealing it and make sure that this plan is done.
Any other comments or questions from members of the committee? We still need to move the amendment, the A5 amendment. Chair Liebling moves the A5 amendment to remove that section 7. All in favor say aye. Aye. All opposed say no. Motion passes. We are on your bill as amended. Representative Noor.
I just wanted that, we've already approved it, so I just wanted to support the amendment because this will have created a big challenge for many folks who are just arrested or somehow their record has been expunged and we may end up using it against them. So thank you so much, Mr. Chair.
Thank you, Representative Noor. I share your concerns about that. Members, this is the Judiciary and Civil Law Committee. And in the old days, when you were either a bad guy or you weren't, it was easy to figure out because you had a conviction. Actually, that's not true because there were a bunch of bad guys out there who didn't get convicted. We didn't know who they were. But in this case, there are just countless gradations of what that means, and I think we need to learn to get a handle on that and not make it so binary on this because it causes a lot of complications. There is a Mr. Brian Vamstad who's here to testify on us, if he could come down. But before that, Ms. Brecken, you wanted to make a point?
Thank you, Mr. Chair and Representative Noor. One of the things I think that is really important for the committee to realize is that the boards do consider rehabilitation and in fact are governed by Chapter 364, which requires us to consider that. I can assure you that there are certainly one of the first things that we have to look at is whether or not there's a nexus to the practice. If somebody has, been substantiated as a perpetrator of maltreatment or has in some way harmed or, theft from a patient, those, so it has to be directly having a nexus to the practice. I can assure you that over the years, there are certainly individuals, at least I know for the Board of Nursing, that have had successful rehabilitation and have been licensed to practice nursing. The point that the boards were really seeking was to have full information to make an informed decision about licensure at the time of application. Clearly, there's a balance between public safety and giving people a second chance. But it has to be to a nexus to the practice, and rehabilitation must be considered in that process.
Brian Vamstead is not here. Is there anyone else from the audience? Oh, he is here. Okay, well, come on down. Come on. Please introduce yourself for the record and begin your testimony.
Thank you, Mr. Chair, and I just was waiting for my turn. Good morning, Chair Lesh and members of the committee. Thank you for the opportunity to testify today in support of House File 637. My name is Brian Vomstead, and I serve as the Director of External Affairs for Gunderson Health System. This bill resolves an ongoing issue for Minnesota to fully participate in the Interstate Medical License Compact, or IMLC, and benefit fully from the law that was enacted by the legislature and signed by the governor in May 2015. Gunderson Health System is an integrated multi-state organization located throughout western Wisconsin, southeastern Minnesota, and northeastern Iowa. Our not-for-profit system includes a tertiary hospital, 5 critical access hospitals, and over 65 clinics throughout the region, serving primarily rural communities. With over 8,000 employees, including 1,100 residing in southeast Minnesota, we are the largest employer in the region. In Minnesota, we provide services in Harmony, Houston, La Crescent, Spring Grove, and Winona. But for the committee today, I wanted to illustrate our experience with the IMLC and what it means for patient care as a multi-state organization. In fact, just last week, I was accompanied by one of our credentialing specialists to testify in Madison to continue Wisconsin's participation in the compact following a 5-year trial period, which was part of their original legislation. I am pleased to report that since the enactment of the IMLC and creation of the commission, Gunderson has been onboarding providers with a multi-state license. In the past, the credentialing and obtaining a state license could take 6 months or even longer. This created challenges of licensing a provider in our tri-state region, especially for outreach and telehealth services. Since the compact's creation, licenses are now issued in just 1 to 2 months. The process is seamless and has allowed our providers to expand specialty services to our rural regional clinics and hospitals. However, due to the technicality between the Minnesota statutes and regulations by the Federal Bureau of Investigation, we have not been able to credential health providers in Minnesota as the state of their primary licensure. House File 637 seeks to remedy this barrier. We plan to continue growing the number of providers and specialty care services licensed through the IMLC, including behavioral medicine, cardiology, pediatric subspecialties, just to name a few. In fact, we recently onboarded our entire infectious disease department through the compact to increase services in rural areas. With the compact assisting and expediting the licensing process, we can provide specialty services to outreach locations in a timelier manner. On behalf of Gunderson Health System, I appreciate the opportunity to testify today before the committee. Our experience with the IMLC has been very positive, benefits access to patient care, and we strongly support Minnesota participating fully by enacting House File 637. Thank you again. I'm happy to take any questions from the committee.
Thank you. Any questions for Mr. Vounstad? Thank you for your testimony, Mr. Vounstad. Any other committee discussion regarding House File 637 as amended? Seeing none, then Chair Liebling's motion is that House File 637 as amended be recommended to be re-referred to the General Register. That's okay, right? Be recommended to be re-referred to the General Register. Does it have to be placed? I think we're good. Okay. That's the motion. That's Representative Liebling's motion. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you.
Thank you, Chair Lash and committee.
The next bill is Representative Masin. Representative Masin is House File 1744. The motion on this is that it's going to go to Ways and Means. So Family Mediation Law Task Force. So is the author's amendment, which one is the author's amendment, Representative Masin? It's A190236. So to get the bill before us, does anyone want to move?
So moved, Mr. Chair.
Okay, Representative Cantrell moves House File 1744 that it be re-referred to Ways and Means. Representative Cantrell further moves the author's amendment, A190236, in order to get the bill in the shape the author desires. All in favor signify by saying aye.
Aye.
Okay, so the A1 is the amendment to the author's amendment. Is that right?
Exactly.
Okay,
just
let's do this.
gives
We're just going to
greater-
have Representative Cantrell do all of them. Okay, so he's moved the A190236 amendment. He also moves the A1 amendment to that amendment. So we're going to vote on the A1 amendment to the author's amendment. All in favor say aye. Aye. All opposed say no. Motion passes. The A1 amendment is adopted, modifying the A19 amendment. Now we're on the A19 amendment to get the bill in the shape the author so desires. This also is Representative Cantrell's motion. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. So now we're on the bill as amended. You got the bill in the shape you want. Representative Masin, go ahead.
Thank you very much, Chair and members. There's a concern about how divorce affects the well-being of children. And a large number of studies have compared children with divorced and continuously married parents, and almost all of these studies have found that children with divorced parents have poorer outcomes on the average than do children with continuously married parents. And in general, it shows that the children that have gone through divorce exhibit more conduct problems, have more emotional problems, and obtain lower academic test scores and grades along the way, not to mention social relationships. And the parents, too, have feelings of depression, anger, loneliness, so the entire family is affected. And personally, since I've been in the legislature, the comments in talking with the parents has been one that I have found extremely distressing. There doesn't seem to be a lot that we've been able to do to help them. So House File 1744 is a bill to establish a family law mediation task force to advise and inform the legislature on the impact of the conflict on children during the marital dissolution process and work to develop a process that will reduce the conflict of divorce through the implementation of conflict resolution procedures. The Commissioner of the Bureau of Mediation Services will provide support, staff, office space, and administration tasks through the process. And also, the committee set up, there will be a task force, they will select their own chair. The best way, we're hoping, is to help divorcing parents provide a cooperative resolution process at the time of the divorce. And client-centered mediation teaches and empowers parents to constructively resolve their problems in a manner that focuses on reaching agreement about parenting plans, schedules, and hopefully there'll be a changed behavior to benefit the children, and a host of issues that are better decided by the parents than the court process. And in your packet, you should also have a letter from Legal Aid supporting this bill. And with me today is Diane Anderson, a former legislator, who will give you some more background on this.
Former Representative Anderson, welcome back to committee.
Thank you. My name is Diane Anderson. As they said, I'm a former state representative. I'm here representing myself today. And I want to thank you, Mr. Chairman, for taking the time to hear many family law reform bills this year. Reforming the laws regarding divorce and paternity are long overdue, and we are so grateful to you and for your help. Thank you, Mr. Chairman. I testified in the Judiciary Civil Law Committee around 28 years ago regarding issues my husband and I were having with being denied the court-ordered parenting time with my husband's son, Kenny. Kenny was around 3 to 4 at the time, and now Kenny is 32 years old. After the hearing was over, Representative Andy Dawkins came up to me. He was so moved by my testimony that he wanted to help me with the problems we were having with the divorce system. I worked with Representative Andy Dawkins on several bills to reform family law, and we passed the parenting plan legislation in the year 2000. My life was ruined by the adversarial court process. We spent thousands of dollars on legal fees just to enforce the parenting time that was in the divorce papers. There were lots of missed birthdays, family vacations, holidays, even Christmas, and family events. There was a lot of conflict with Kenny's mother, and using the court system was not a way that we could get things resolved. We went to court 3 times one year just to enforce the court-ordered parenting time. Kenny did not do well at handling the conflict, and at age 13, Kenny decided that he did not want to come to our house anymore. And we have just recently reconnected with Kenny. He's having a lot of problems with the family law system himself. He has a paternity case, and he never gets to see his son now. And I was hoping that he would be able to come today and tell you about his story, but he decided not to. But I have a 7-year-old grandson that I have never seen. We need a different and better process for families to go through regarding divorce and paternity cases. We need to look at how the adversarial divorce process is harming our children and our families. We should find ways to move away from this adversarial court process. If we would have a non-adversarial court process method, we can help to reduce the hostility that often accompanies people who are going through a dissolution. Such processes can help parents minimize the conflict that they have with each other and will help to minimize negative consequences to the children. A non-adversarial process can also improve voluntary compliance with parenting issues and the parties that they have. You know, there is a lot of research out there about the effects of divorce, and Representative Masin listed a lot of the things in her testimony. And so by having this task force, it's going to be a very effective way to bring people together to talk about the issues. We will get information from professional people who understand the issues that people are experiencing as they go through this divorce process, and we can come up with some ways that will help give us some ideas and solutions that we can use here in Minnesota. So I would like to find some legislators who are willing, just like Andy Dawkins was willing, to spend some time understanding what is happening to people in the court system and develop some legislation to reform some of the problems people are having with the court system. So I would like to see things changed for our future generations, as they do not have to experience what I had to go through and what many other people are going through. There is a tremendous pain when you're labeled a non-custodial parent. You are told that you are not the parent, you do not matter, and you don't have any rights to your child. There's tremendous pain when your child is taken out of your life. So for the sake of our children, I'm asking for your support for this bill. In 2017, there were 7,477 divorce cases involving children, and in 2018, there were 7,444. And we have a duty to help the parents and the children who are affected by the divorce. Thank you.
Thank you for your testimony, Ms. Anderson. Any questions from members of the committee for Ms. Anderson or the author? Representative Mueller.
Thank you, Mr. Chair. And I do like this bill, and I just had a quick question about, or maybe just a comment about, I didn't see any representatives from the Battered Women's Coalition in here, and I just want to make sure, even if they're not on the task force, that those issues related to battered women are also going to be considered by this, just because the dynamics are very different in those relationships. And mediation, you know, may or may not be appropriate in all of those situations. So I just wanted to point that out, and hopefully that will be a consideration.
Okay, if
Mason.
legal aid were here, they would testify they are on the list.
Okay, great. Thank you.
Yes, Mr. Chairman, there is a letter in your file from Ron Elwood. So they were added in between these two committees, and that's the group that will represent the battered women.
Thank you very much.
Any other, Representative Neal?
Just a quick clarification question, because the letter was written to government operations, and I was looking at the bill with the path, and I don't see, at least on the version that we have, that it went to government operations, did it?
There was a clone bill, is my understanding.
Exactly. It's House File 2318 was done, is a clone of this bill, and that's what GovOps heard the other day.
Representative Neal.
Okay. All right. And then I just have another small little question. Mediation Services is setting this up, and I guess that we don't talk about them much. I'm just wondering, do they do other task forces in this area?
Okay.
I'm sorry, I didn't hear the question.
The question from Reps O'Neill is whether Bureau of Mediation Services has done other task forces in this area. I know that we've been working with them on cooperative divorce piece, but are you from Bureau of Mediation? Here, they're right here. Reps O'Neill, come on down.
Thank you, Mr. Chair. Members, my name is Mike Stockstead. I'm the Deputy Commissioner with the Bureau of Mediation Services. Representative O'Neill, in direct answer to the question, yes, we have done these before. We do them actually pretty regularly. One of the ones similar or related to this, we did a child custody one just a few years ago. But when they're tight time framed like this, we put one of our professional mediators on it and devote about a quarter of their time just to make sure that we can meet the deadlines.
Reps O'Neill.
Thank you, Mr. Chair. And so that would explain the fiscal note, that you need a little bit of additional support to do this.
Yeah.
Sorry, Mr. Stockstead, go ahead.
Mr. Chair, Representative Neal, that's correct. While the mediation staff are exempt staff, the support, we would have some overtime with our clericals as well, but a devotion of part of their time would also be part of that, yes.
Thank you, Mr. Chair.
Reps O'Neill. Yep, okay. Any other questions? Chair Considine.
Thank you, Chair Lesh. Again, I like the bill, and I think the intent is wonderful. But as Representative Moeller pointed out, there are potential for a lot of pitfalls, and I think when the task force comes back with its recommendations, this committee is going to need to scrutinize that carefully. I think I had half a dozen quick potential pitfalls jump to mind. I don't want to go through everything, but let's see what they come up with first and then take a look at it. But there's potential for abuse. Yeah. Thank you.
Representative Carlson.
Thank you, Mr. Chair. Perhaps a clarifying question for staff. I'm looking at the amendment to the amendment with open meetings, and I see this a lot, and I don't recall what the answer is. So line 1.5, the meeting of the task force occurs when a quorum is present. So is a quorum based on the members present, or is it based on the membership of 16 members? So what's quorum?
Well, Ms. Mullen, is this your department? I mean, quorum is, I mean, that's a parliamentary question, and unless it's defined anywhere else in statute, quorum is a majority of the membership.
Majority of the membership, correct.
Yes.
Okay, and that's how we should read this.
I mean, that's the way I would read it, unless someone were to notify me that it's defined differently in agency rules, which the Bureau of Mediation Services could tell us that they'd done through rulemaking or by state statute, and I can't imagine it would be defined specifically in state statute in this. So for all purposes, it would be a majority of the
membership.
Yeah.
Thank you, Mr. Chair.
Yeah. Any other questions for the author? Chair Scott.
Thank you, Mr. Chair. And I'm just wondering if the open meeting amendment that we just adopted, was that already on the clone bill when it went through GovOps? Because this, even though it seems related to us, open meeting law stuff actually goes through that committee. So I'm just wondering if it was attached to the bill at that time.
Representative Masin.
And actually, it was not. House Research just suggested adding that in the interim.
Right. So, Mr. Chair, that might need to go, probably does need to go back to GovOps, but I'm definitely in favor of this bill, and I think it will help. You know, I'm looking forward to the what the task force comes up with to see what we can do to make this process of going through divorce and separation a better one for everybody involved. So, thank you.
As I said, I've heard
Thank you.
a lot of concerning or distressing comments over the last few years.
Well, thank you, Representative Mason. Then the motion, I think it was Representative Cantrell's motion, right? Okay. That's the only reason I remember, is it just made him make all the motions, and then I wouldn't have to guess who it was at the end. So the motion that he makes is to re-refer it to Ways and Means as amended and amended. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. The bill is re-referred to Ways and Means as amended. Thank you, Representative Mason, for being here.
Chair members, thank you very much.
Representative Lee, come on down. You're the next contestant. And someone want to move Representative Lee's bill, House File 167? Chair Considine moves this. And the motion on this is that it be re-referred to Ways and Means. Do you have an amendment, Representative Lee?
Mr. Chair, I don't.
No amendments. Excellent. Okay, go ahead to your bill.
Thank you, Mr. Chair and committee members, for the opportunity to present House File 167. Members, this bill aims to address the important public health concerns Minnesotans impacted by pollution have when the state enters into enforcement settlements with polluters in our community. It provides an opportunity for communities to be heard about how settlement funds can be used to address their health concerns. And for background information, in March 2017, the Minnesota Pollution Control Agency agreed to a $2.5 million settlement with a recycling company in my district that violated multiple air standards. Of this $2.5 million, only $600,000 was allocated to the city of Minneapolis for community health projects. And this level of funding for community health projects is unacceptable to my constituents because of the health disparities that we have compared to the state. The Minneapolis Health Department has identified the neighborhoods surrounding the recycling facility as areas of concentrated poverty where 50% or more of the residents are people of color and are at risk for both asthma and lead poisoning. And Mr. Chair, to my bill, it provides for offers of supplemental environmental projects, or SEPs, in enforcement actions against polluters. Currently, the PCA often use SEPs in enforcement settlement to provide extra environmental and public health benefits. These projects, which a regulated party or respondent agrees to undertake in a settlement of an enforcement action, but the regulated party or respondent is not otherwise legally required to perform. These projects can be conducted by a regulated entity, or they can pay a third party to conduct it. My bill requires the PCA commissioner, in consultation with the Commissioner of Health, to offer public health SEP projects when the pollution in question results in measurable health impacts to the population exposed. In other words, the PCA is required to offer this voluntarily program that reduces their penalty and benefit the community. If a project is accepted, the bill requires the commissioners of PCA and Health to approve the public health project and certify the project's completion. My bill also requires the commissioner of the PCA to ensure that the community actively participates in developing a public health SEP. And this bill is in front of the committee because of the privacy of health information concerns that were brought forth from members of the Environment Policy Committee. And in the Health Finance Committee, we adopted an amendment to address these concerns. And so, Mr. Chair, these sections pertinent to your committee are Section 1, 2, 3, and Section 4, Subdivision 5, related to privacy of health information. And Section 1 allows for health information collected, created, or maintained as part of a public health SEP to be disclosed as Subdivision 5 of my bill of Section 4. Section 2 creates a subdivision called Supplemental Environmental Project in the Environmental Protection Data section. And Section 3, currently a state official may not start, pursue, or settle litigation or settle a matter that could have resulted in litigation in a way that would result in someone or entity getting money other than the state. And so my bill does not prohibit an entity or a polluter in this case to enter into a settlement agreement with the commissioner of the PCA from contributing money to a public health project. And Section 4, Subdivision 5, the privacy of health information, this subdivision say that a regulated facility may not release or disclose health information as written and as specified in a written informed consent from the form from the individual or a legally authorized representative, or to the PCA or to MDH, and pursuant to a specific authorization and law. It also requires a regulated facility to establish appropriate security safeguards for protecting the privacy of health information. Further, upon request by an individual subject of health information and maintained by the regulated facility or that person's legally authorized representative, a regulated facility must supply a complete and current copy of all health information relating to that person. And additionally, the bill requires that if a third party conducts or manages a public health SEP on behalf of a regulated facility, it must comply with the data provisions if it were a regulated facility. A regulated facility, PCA and MDH, may disclose health information to the third party as necessary to administer the project. And a regulated facility or third party must certify in writing that it will comply with the data provisions before the PCA and Department of Health may approve it for a public health SEP. The bill goes on to specify that the Department of Health may disclose health information to a regulated entity or the PCA as necessary to administer the project, and that the PCA may disclose health information to a regulated entity or MDH as necessary to administer a public health project. Lastly, the bill specifies that MDH may establish a review process to ensure that privacy is maintained with respect to any data collected or developed under a public health SEP. And Mr. Chair, that is my bill.
Okay, questions for Representative Lee? Chair Scott.
Thank you, Mr. Chair, and thank you for bringing this bill. I noticed you mentioned it in your review. You did a very thorough job, by the way. On 613 through 6.15, and then again on 6.17, it says the commissioner may disclose health information. And I'm wondering, is that going to be identifiable health information or de-identified, some of each, or if you know, and kind of, if you could walk our committee through what kind of information they would actually want to share with this, you said regulated third party, is that right? And what is, give us an example of what a regulated third party would be, if you could, too.
Representative Lee.
Thank you, Mr. Chair and Representative Scott. So an example that I could share with you is what is happening with the $600,000 that's coming from that settlement in my district to the city of Minneapolis. And what that money is being used for is to identify and educate at-risk residents of asthma triggers, to enroll families with children suffering from poorly controlled asthma in a new asthma trigger mitigation program, to implement community and blood level screening events in cooperation with the local clinics, and to identify and connect affected individuals with resources to reduce environmental exposures because of the pollutions.
Okay.
Chair Scott.
Mr. Chair, and one other item, I know on 6.20, it talks about the department may establish a review process to ensure the privacy is maintained, et cetera, and I apologize, I didn't have an amendment for today, but I think that should be a shall. And I think, because you're going to be handling some, or these entities are going to be handling some really sensitive information. So I think that should be a shall. And I think one of the things that we've been doing when information is shared like this is we're requiring an audit trail to be created so that we know who has had access to that information, where it's been shared, and for what purposes. So would that be anything that you'd be open to?
Mr. Chair, Representative Scott, so thank you for that, and that's something that I'll be open to. We do have another stop. The stop is in environment finance, and we could definitely incorporate that into the amendment and the bill when we get into the environment finance.
Thank you, Mr.
Chair
Chair.
Scott.
And I have a feeling maybe the Department of Health already has the means to do that, but to create these audit trails. And then the other thing is if you're working with a private entity or this third party, they would also have to have a way of having an audit trail. And then sometimes those are, an audit is performed annually, sometimes it's, every other year. So those are some things to keep in mind as well. Thank you, Mr. Chair.
Any other questions for Representative Lee? Representative O'Neill.
Thank you, Mr. Chair. I guess I just wasn't clear in the answer that Representative Scott asked about de-identified health information, or if it had specific information about specific people. It's just not real clear in the language, and I didn't hear that really in your answer. Can you tell us this information that you're, again, that was the same sections that Representative Scott just referenced, which was 6.13 through 6.15. And actually the next couple sentences talk about the health information. Can you just tell us if that's de-identified information, or is it specific to a person and they're identified?
Representative Lee.
So, Mr. Chair and Representative O'Neill, so the data that will be collected, my understanding is that it will be de-identified, and then if you look at section line 3.26 onwards, public health SEP includes but is not limited to the collection analysis of epidemiological data, collection analysis of fluid, blood, fluid, or tissue sample, medical examinations of potentially affected persons, and medical treatment. So those are the types of data that will be collected, and the staff, the nonpartisan staff that was working with me on this is not in here, so that's something that I could reach out to and get some clarification on.
Mr. Chair.
Representative, okay. And Chair Johnson. Oh, sorry, Representative Hassan.
Actually, I just had a quick call.
Oh, go ahead, Representative O'Neill.
Sorry, Mr. Chair. So, that's incredibly important because that's a whole other level of data. I just have one other quick question. So can you just help us understand the process by which you're gathering all of this, very private health information? How is it gathered?
Representative Lee.
Thank you, Mr. Chair. And so that's something that the the entity will have to work through, and it will have to be certified by the PCA and the Department of Health before they could go forward with that.
Mr. Chair.
Representative O'Neill.
Thank you. I'm specifically asking, are you going door to door, asking members of the community to provide this? I'm not sure how you get to this information. Do you have a plan for that?
Representative Lee.
Mr. Chair and Representative O'Neill, like I said, that will depend on the project and the type of project that they're going to do. And in the example of what happened in my district, that's what they're doing. They're going door to door to let folks know about the project that's going on. And like I said, with regards to Minneapolis, they are doing that, and they are looking at blood lead levels, and they're providing screening for that. And so that's an example that's happening right now in my district.
Representative O'Neill.
Thank you. I'm just trying to get my mind around this. So you're going door to door and asking people for blood and tissue samples and things like that. That's what the bill says. I'm assuming you're leaving them some documentation so they can go to a clinic or something and have those things taken from them. Would that be accurate?
Representative Lee.
Mr. Chair and Representative O'Neill, the details of that will have to be approved by the PCA, then the Department of Health.
Okay. Thank you, Mr. Chair.
Representative Hassan.
Thank you, Mr. Chair. Thank you, Representative Lee, for bringing this bill. We know that many of poor people and people of color are impacted by this issue. I am from a district that has the highest asthma rates in the whole state, and that's a result of companies being very careless and not, doing their due diligence when they're, working with chemicals and hazards to our environment. And on the health, information, I'm hoping that this process will follow the private health data, because that's already in place, and HIPAA is in place, and this is a protected information. So whatever agency is working with this, hopefully will follow that as well, and whatever information is available will be non-identifiable information. Is that correct?
Representative Lee.
Thank you, Representative Hassan, for that. And if I could turn it over to Mr. Hopkins to help. He helped me answer that. He was one of the staff members that was able to help me draft this specific language regarding privacy of health information.
Mr. Hopkins.
Mr. Chair and members, so the information that would be collected and shared between the entities specified in the bill would not be de-identified information. The point of the bill is to provide health care and support to specific persons affected by the regulated entity under the bill. So it wouldn't be de-identified, because then you wouldn't know who to provide health care to. So the information is subject to the protections under the bill, but it's not de-identified.
Representative Hassan.
Thank you, Mr. Chair. And so I would suggest that we add a way to protect that information for, so then we don't end up with, another lawsuit of, data being exposed about people. I mean, it's good that we're trying to have community input, because most times there is no community input. And it's a lot of times, like I said, it's communities of color and poor communities that are impacted by this. And somebody else makes the decision. They don't make the decision. And it's good that this bill will allow some community input for people to come and make decision about their environment and what's happening to their children. So thank you.
So, Mr. Chair, just to that point, line 5.24 to 5.28 says that a regulated facility must establish appropriate security safeguards for protecting the privacy of health information, including procedures for ensuring that health information is only accessible to persons whose work assignment reasonably requires access to information and is only accessible by those persons for purposes described in the procedure.
Thank you. Representative Hassan.
Thank you, Mr. Chair. Thank you, Representative Lee. This is a very important bill, so thank you for bringing it up.
Chair Johnson.
Chair Lesh, Representative Lee, going back to what Representative Scott brought up on line .620, the May issue. Because of this information that were being collected, and it's unredacted information needed to provide the health care for some of the people involved. I can't stress how important it is to change that to shall. It's very important.
Representative Hur.
Thank you, Chair Lesh and Representative Lee. I know that you and I had a chance to talk about this a little bit beforehand, and I just wanted to say that I appreciate all of the work that you've already done in incorporating all of the feedback you've received in the different stops that you made. And I'm just curious, I know that sometimes it feels like things are brand new and they're super innovative, and it's never been done before, but systems of collecting health data and information using a third party or entity, it's actually been done quite a bit before, right? How different is this from companies that right now, if you apply for life insurance through your company that's above the amount that's allotted to you, they have to send out somebody to collect your samples and then keep that data and protect that data. And because each project is very different, these types of entities that do this type of work already exist, and we're not really creating something brand new. Is that correct?
Simply. Mr. Chair, thank you. And kind of to address that issue before I turn it over to staff, I actually asked Mr. Hopkins about this too. And I do want to let members know that the PCA are currently doing some of these already. And what we're doing in here is putting into our state statute and actually providing that protection and that safeguard for the information. And Mr. Chair, if I could ask Mr. Hopkins to answer Representative Hur's question.
Mr. Hopkins?
Mr. Chair and members, under current statute, whenever a government entity or a private party collects genetic information about an individual, it's subject to protections under Chapter 13. That would include life insurance companies.
Representative Hur, you're good? That's good. Thank you, sir. Okay, Representative Lucero.
Thank you, Mr. Chair, and just a few questions along the same lines to the bill author. So as I'm looking at line 3.13, agency, as we've been discussing, is the MPCA. The commissioner on line 3.14 is the commissioner of MPCA. Then, starting on line 3.15, health information means any information, whether oral or recorded in any form or medium. So that could be digital or hard copy. So given the definition of agency commissioner and that the information can be any form whatsoever, and then maybe it was said earlier, I didn't catch it, could you repeat or say, where is this going to be retained? Is this going to be retained by MPCA or is this retained some other agency?
Representative Lee.
Thank you, Mr. Chair. So the data will be retained by the entity that's performing the project. So that could be the regular entity or the third party that they pay for.
Representative Lucero.
Okay, thank you, Mr. Chair. So the collection, as Representative O'Neill brought up, the collection of its genetic information or other information, it might be retained by a third party or by which agency in the state government? Would it be something other than PCA?
Representative Lee.
Mr. Chair and Representative Lucero, the data collected will be either the regular entity when they decide to take on a public health SEP or the third party that they pay to do the projects on their behalf.
Okay, thank you. So just to be sure I'm clear then, so the information that would be collected as part of this would not be maintained by another government entity. It'd be retained by the regulated entity, which would be a non-government agency, or a third party. That's where it would be, I mean, is what I'm hearing you say.
Yes.
And then, okay, so then getting back to the other question on 5.24 that you read, establish appropriate security safeguards. Whenever I hear the word appropriate in the field of cybersecurity, that is so generic and ambiguous, it means almost nothing. So how are we going to ensure that these third parties now, when they're going around neighborhoods and collecting not just private information like social security, potentially date of birth, first, middle, last name, address, but genetic information now? Where is this genetic information going to be stored? How long is it going to be retained? What are the controls around this? Much more clear than the word appropriate, I guess would be, I have a huge concern with that, Mr. Chair, and that's rheltorical. Thank you.
Mr. Chair, I'd like to
need to answer, Representative Lee.
turn it over to Mr. Hopkins again. He was the one to that helped me draft the language. My understanding that this is the mirror language that we have in place already, and Before I go further, I would like to turn it over to Mr. Hopkins.
Well, okay. Go ahead, Mr. Hopkins.
Mr. Chair and members, so yes, that language is very similar to what exists in current statute 13.05, subdivision 5, which deals with what a responsible authority in a government entity has to do. Says that section says that they have to establish appropriate security safeguards for all records containing data on individuals. Generally speaking, the reason that we would use a term like appropriate security safeguards in statute is because technology evolves so quickly that if we specify precisely what kind of security safeguards need to be in place, those could become outdated in the next couple of years. So the goal with a word like appropriate is to make sure that it allows the government entity or the individual subject to the statute to be able to keep up with evolving standards, evolving security standards. So appropriate would mean appropriate at this time for this purpose to protect this kind of data. So that's why that's the function of a word like appropriate in a statute like 13.05 subdivision 5 or in the bill. That would be the intent of the word appropriate there.
Okay, sure. No, Representative Lucero, I agree with you. Appropriate means everything and nothing. But there are people who feel good about having it there. So we're going to leave it there for now. Okay. Chair Scott.
Pass.
Okay. We have a testifier. Members, we do have one other bill. Representative Pinto has been patiently waiting almost the whole time, in fact. Welcome to Judiciary Committee, Representative Pinto. I'm sorry, but no, I mean, you're not up yet. I'm sorry for making you wait, is what I meant. But we do have Jeff Smith, who's the director of the Minnesota Pollution Control Agency. If you can just keep your comments brief, Mr. Smith.
Mr. Chair, members, my name is Jeff Smith. I'm the director of the Industrial Division at the Pollution Control Agency. I will try and keep my comments brief. I think we've been working closely with Representative Lee on some alternative language, but I did want to get on record to say that we have still some significant concerns about this bill in its current form. It does not address the privacy concerns that have been expressed here. I think one of the things that this committee should consider is turning over, and this is how the SEP process works right now, that the regulated party is responsible for managing and hiring a third party to take over and follow through with what's required in terms of public health or environmental SEPs. Keep in mind that most of these regulated parties can be as small as mom and pop shops, 2 people. It can be a large corporation. We have about 10 of these per year that may fall into this category. It's my belief, working with these regulated parties over many years, that they're going to be unwilling to take on the responsibility for managing the privacy data and individual health data from people. They have not the sophistication or the ability to do it. They're not going to be interested in doing that. The bottom line is, because this is an option for those regulated parties, I can tell you that no one's going to opt in for this particular effort. We do support, the agency does support the directing of funds collected from penalties to local units of government for some environmentally and human health beneficial projects, but this will not result in that. No regulated party will adopt this or voluntarily agree. And one of the reasons they won't is because this is going to significantly add on to the time before we can resolve noncompliance. The SEPs must be resolved and documented in the stipulation agreement or consent decree, which is the governing environmental enforcement document. This will add on a significant amount of time, months, if not years, to go through a public participation process, as well as address all of the privacy and health concerns. And because that's the case, regulated parties who often want to get these non-compliant situations wrapped up quickly and move on to fixing the problem and getting on to business, again, will be another reason that regulated parties will not choose to do this particular bill.
Okay, Representative Considine.
Thank you, Mr. Chair. Representative Lee, I think this is a great idea and a really good bill. I think in the long run, it will benefit individuals and communities all over the state. Thank you.
Thank you. Closing comments, Representative Lee.
Thank you, Mr. Chair, and just to address some of the points that were made too, and this bill was really brought forth because my constituents feel like they have not had the proper response from the agencies that are tasked with our public dollars to really respond to their concerns, and this is just one of the tools that we are providing for the PCA, and when they're reaching out to our communities that have been impacted by pollutions in our communities. So I just want to say thank you for the opportunity to present this, and I will take into consideration the remarks from members of the committee and hope that you will support the bill. Thank you.
Thank you, Representative Lee. Representative Considine's motion is that House File 167 be recommended to be re-referred to Ways and Means. All in favor say aye. Aye. All opposed say no. No. Motion passes. The bill is referred to Ways and Means. Thank you, Representative Pinto. Thank you for your patience. Representative Pinto has up before us House File 2319. Does anyone want to move House File 2319?
So moved, Mr. Chair.
Representative Hassan moves House File 2319, and her motion is that it be recommended to be referred to Ways and Means. And Representative Pinto, you have no amendments, is that right?
That is correct, Mr. Chair.
Take to your bill.
Thank you, Mr. Chair and members. Glad
If
to
I
be back.
can, beforehand, Representative
Yes.
Pinto, just to be clear, we're looking at Section 1, 2, 3, 17, 20, and 21. Those are the provisions relating to immunity in the civil fines portion and data practices.
Mr.
Go
Chair,
ahead,
could you repeat those again, please?
There's sections 1, 2, 3, 17, 20, and 21.
Thank you, Mr. Chair.
Actually, 21 is even criminal penalties. I don't even know, we need to look at that, but it's not going to public safety, so whatever. Go ahead, Representative Pinto.
Thank you, Mr. Chair. Yes, that's my understanding that this, just the focus is on those 6 sections. So this is this are proposals from the Department of Human Services relating to program integrity for a number of human services programs. I have the commissioner here who can help us walk through those specific 6 sections for folks. Maybe just in the interest of time, we'll just kind of dive in with that and move to questions and then go from there. So.
Okay, excellent. Welcome to the committee. Please introduce yourself for the record. Begin. your
Mr.
testimony.
Chair, members, my name is Chuck Johnson. I serve as Deputy Commissioner at the Department of Human Services. Thanks for the opportunity to present these department provisions around program integrity. We take program integrity seriously at the agency. Fraud, waste, and abuse costs millions of dollars in dollars that could be going for legitimate services to people.
And I'm not sure if the microphone's.
Representative Pinto.
Is it on?
What?
Was the microphone? I just wasn't sure if the microphone. Folks hear the commissioner?
Oh, I
Okay.
heard him.
Okay, good. Thanks. Sorry. Okay,
Thank
please
you,
continue.
Mr. Chair. The provisions here cover different, both medical assistance and child care assistance program to some extent. Some of them cover both. So I will go through the sections in order, and then as Representative Pinto said, we can take questions after that. Section 1 on page 1. This relates to sharing of investigative data. This would allows us or clarifies that we are allowed to share the data from our investigations for fraud in both the child care assistance program and in medical assistance with other law enforcement as well as with county fraud investigators. We do this generally now, but it is a question that's come up because generally speaking, open investigation data is considered not something you can share. Our investigators are not sworn officers of the law. They are state employees. So we want this to be very clear because the sharing of that data is really important to effectively managing investigations and getting prosecutions. The second section 2 deals with liability, and this deals with the Federal False Claims Act. This would bring Minnesota into conformity with the Federal False Claims Act. We are currently out of compliance with that act, and why that matters, particularly from a DHS perspective, is there's incentive payments that we can get on recoveries under the Medical Assistance Program, Medicaid, a 10% incentive for the state that we only get if we're in compliance with the False Claims Act. Currently, the penalties that are in Minnesota statute around false claims are not at the level that they are within the Federal False Claims Act. This would align us to the Federal False Claims Act. Department of Justice, this came about a couple of years ago. The Department of Justice at the federal level gave us an extension through the end of calendar year 18, but as of January 1 of 2019, we're out of compliance. What this means is, for example, a lot of our Medicaid payments are 50% state, 50% federal. When we make a recovery, we give the federal government back their 50 cents. If we are in compliance, we actually get to keep 60 cents and only give them back 40 cents. So it's a benefit to the general fund of the state to have this provision aligned to the federal law. Section 3, which is on page 3, relates to the Child Care Assistance Program. This clarifies or establishes what data we can share publicly on child care assistance payments. This is a question that's come up recently as we've had a number of requests around data, and we have an IPAD decision from 2006 that says we can't share the amount or who we're paying child care assistance payments to. This seems kind of counterintuitive. We're paying this to child care centers. These are businesses, generally speaking. State, including legislators, who are making a lot of the requests of us, are very interested in where those dollars are going. This would allow us to share that information within some parameters. We set a $100,000 threshold on this so that we would only share if it were above $100,000, which helps us protect the possible identification of individuals who may be receiving CCAP, which is important under the data privacy laws. It also would apply only to centers and license exempt centers, not to family-based child care. And we'd be able to share data either on any provider who was paid over $100,000 or when that provider has been subject to some kind of a negative action due to financial misconduct or fraud. And again, this is information that we've been asked for a lot and we can't share, and there's been a fair amount of frustration around that. We believe this clarification would help to make it easier for us to be transparent about where CCAP dollars are going. The next section, we skip ahead to section 17, which you find on page 16. This relates to immunity for good faith reporters. Currently, for people that report to us, or reporting fraud or potential fraud to us on some of our providers, we'll often ask, can I be anonymous? And we can't hold them anonymous. Once the investigation is done, that information does become public. We have actually had a reporter who faced civil lawsuits, even though they went through a good faith reporting, actually got sued civilly for having made that report. We do have similar anonymity in law for reports on vulnerable adult abuse as well as on child abuse. We think this would help in terms of bringing people in and getting better information from the public and allow us to better identify and move forward where we have fraudulent providers that we need to take action on. The next section is section 20. This is on page 18. This relates to the medical assistance Medicaid program. Currently, for investigating and entering into investigation or taking action against a provider within the medical assistance program, we have to give the provider 24 hours notice before we show up in their office. And by giving them 24-hour notice, as you might guess, this creates potential problems in what data is available when we get there, what that data looks like. That's not a restriction we have within our CCAP investigations, for example. We believe that it really prohibits us from being able to do good investigations when we identify a problem, be able to go in and on demand have that provider have to allow us into their office and share whatever documents or records we need to execute our investigation. And we think this clarification would be important going forward. And then finally, Mr. Chair and members, section 21 on page 19 of the bill addresses kickbacks. This establishes in law a law that says that kickbacks are criminalized within Minnesota law for the purposes of public programs, and this is again a reference to child care assistance and the Medicaid program. This is modeled after the federal kickback law, anti-kickback statute. It applies to both providers and recipients, so no matter matter which way the kickback is going, it would apply. It really helps prosecutors have an easier time of proving that there was theft and establishing the amount that has been stolen as part of these schemes. We see kickback schemes fairly frequently, both within child care assistance and parts of our Medicaid program. We think it's important to have this clearly in state statute. It can lead to overutilization of services, to billing for services that are not rendered, for billing services that aren't medically necessary. People choosing a provider based on a kickback as opposed to basing on a quality of service or the actual services that they need. And is, of course, an unfair competitive practice within these areas. So we believe that criminalizing the provider and recipient kickback will help fill this gap in Minnesota law and help us tighten up our ability to be able to prosecute those schemes when we see them. Mr. Chair, that's my overview.
Thank you, Mr. Johnson. Any questions for Mr. Johnson? Chair Scott.
Thank you, Mr. Chair. And I'm really glad to see that something is starting to be done on this, particularly CCAP fraud, and I think it goes broader than that. In your estimation, you're an assistant commissioner, is that right, Mr. Chair?
Mr. Johnson.
Mr. Chair and Representative Scott, Deputy Commissioner.
Deputy Commissioner, thank you. I'm just wondering overall what you think this will do to address the CCAP fraud issue.
Mr. Johnson.
Mr. Chair and Representative Scott, I think that these provisions will help a lot, and there's, obviously another 16 sections in the bill that will be heard in other committees, which are also part of our efforts around program integrity that will help address a number of those issues. Those in concert with a number of the provisions that are in another Representative Pinto's bill that the department and the governor proposed around tightening up some of the controls within the child care assistance program. In addition to some supplemental proposals the governor is going to release on Friday, that will help us in terms of better oversight by giving us some more licensing staff to do heightened monitoring around centers where we have suspicions, and also just new centers, because new centers often struggle both from a technical assistance standpoint and potentially from a compliance and cooperation standpoint. Providing us with more data analysts, because we need to do better analytics on our data to be able to get ahead of the fraud, identify where we think the most common schemes are the most, the programs we need to be looking at most closely, again, both on child care assistance and in medical assistance, where the schemes are often similar for something like personal care attendants or home health, very similar kinds of fraud that we see going on. So those provisions will help us a lot, I think, to make progress there. There are a couple of other things that were recommended by the contractor we had doing an overview of our CCAP program for us that are a little bit longer term that I think will be big steps too, and the governor's budget, supplemental budget, will help us support work on that. One is a electronic attendance system. Which will allow us to be able to, probably for larger programs, we need to figure out for who, have a good electronic way of having oversight and controls around attendance, which then feeds into billing. That whole nexus of attendance tracking and how it gets billed is one of the really critical points in providing clarity within and integrity within the child care program. We're actually doing something very similar on the Medicaid side with electronic visit verification for personal care attendants and home health. That's in process now. So I think those are some important tools that we can bring forward over the next, well, some are going this year, some we can bring forward over the next year or two to help.
Thank you, Mr. Chair. And I did have one question regarding investigative welfare data. And it says, I believe, that you can have access to that investigative data even in the midst of an investigation. Maybe I'm not reading that correctly. But then also, how would that overlap if law enforcement is doing investigation? At what point is there an intersection of the department doing an investigation, and at what point do you hand it over to law enforcement or whatever? If you could walk us through that a little bit, please. Thank you.
Johnson.
Mr. Chair and Representative Scott, sometimes we find that there may be investigations that we're doing and law enforcement might be doing one, or the county may be doing a recipient fraud investigation, which actually ties to a provider fraud investigation that we're doing because of kickback or some kind of a mechanism like that. So it does help with sharing in those instances. We're working on having a better controlled point as to when and how we make decisions about handing a case off to law enforcement, particularly within the CCAP area, where I think we have some room for improvement there based on some of the audits that we've received around that. So we want to have a case that is ready for law enforcement to help us identify what more we need to do, but at the same time, be ready enough for them to be able to run with, so we don't waste 2 years of work and then find out that the prosecutor doesn't really feel like there's enough there for us to work with. So that relationship is really key, and having an open communication, but also doing it at the appropriate time and not not bringing law enforcement in before we really need them.
Thank you.
Scott, you good? Okay, thank you. Chair Johnson.
All right. Chair Lash, Representative Pinto, and to the testifier. I don't believe we dealt with Section 2, and we're not supposed to, but it caught my attention during the overview. In 2015 is when the federal act went into place. And now you just bring it up in 2019 to get in compliance, and you had to do an extension that expired a year ago. I'm just wondering why this wasn't taken care of in the department bills that we get yearly. This is something that should have been taken care of right away, and I'm just a little disappointed that now that we're out of compliance, we have to do it real quick, rushingly. So that's a little bit of disappointment I have, along with reading some of the OLA report. Very concerning. One thing with the investigation part of it that you talked about in this what that was in the OLA report is taking the Office of Inspector General and putting that outside of Health and Human Services as an independent type deal. I noticed that's not in this bill. And for us, it's a little hard to comprehend everything. We were trying to read the OLA report, but on the House side, we have not even had a hearing yet dealing with these issues for an overview of the OLA report. So it's trying to grasp everything that's going on here is getting a little difficult.
Members, we're at our committee time now, and we have 2 more members on the list, Representative Lucero and Chair Liebling. Representative Lucero.
With that introduction, I would make it quicker then. I guess I'm reading page 1. I was hoping that Mr. Hopkins might be able to identify welfare system as I'm reading lines 1.21 to 1.23. It makes a reference to the welfare system, so I just wanted to get clarification. Does this, I know we're talking CCAP, but does it involve more? So CCAP would just be part of what the welfare system is? Just clarification on that, Mr. Chair.
Mr. Hopkins.
Mr. Chair and members, so welfare system is a defined term in this section of the Data Practices Act. It's very long and expansive. It includes the Department of Human Services, local social service agencies, county welfare agencies, county public health agencies, county veteran service agencies. So I won't read the whole thing, but Native American tribes, to the extent a tribe provides a service component of the welfare system, and agencies, persons, institutions, and organizations or other entities under contract to any of the above agencies to the extent specified in the contract. So it's a variety of county, state, and private entities that provide some sort of social service component. So it's a defined term, and the definition is very broad.
Representative O'Neill.
Thank you, Mr. Chair. Just a real quick question about PAF, because I was just going through section 21, the 2 pages about 609.
They're talking right now.
PAF. What
You're
is
talking
the
about-
intended path? Going to public safety?
Well, I'm sorry, go ahead, Representative O'Neill. I just meant that I think you were asking whether it's going to public safety?
Yes.
Yeah, and I think our public safety chair is up there talking about that right now. So
Okay.
it's going back to Ways and Means, and their division of Ways and Means now also. So whether it goes to public safety after that, it's going to be up to Ways and Means, and you can tell Chair Mariani on the record here that you think it should go to Ways and Means, or you can say no, or
Thank you, Mr. Chair. So I would ask that this would go to Ways and Means. I'm actually working on a different type of bill dealing with the theft statutes, and these are adding quite a few new penalties and law felonies with 5 years with 5 years and $15,000 fines. And I just think that's something that we need to discuss to see if that's in line with the current theft statutes, and there isn't an amount that has been proven to be fraudulently taken. And so that, I just have a lot of concerns about that are not in this committee.
Fair enough. Chair Mariani, did you want to speak to that at all, or whether it's going to go to your committee?
Well, Mr. Chair, it seems to me at the very least, based on how we've been operating this year, where we recognize that there are those areas in between, and it's going to involve studying a penalty of some type, that that what we've said is that we want to avoid duplicative hearings. And it seems to me, therefore, then, that what this committee ought to be doing, because there is a penalty identified here, and it's a new one, at the very least, is asking the question, is this an appropriate penalty? What's the intent of the authors relative to its effect on deterrence, et cetera. We'll be asking the same question if it's in our committee. And I think the way we've operated is, as opposed to sending a whole bunch of bills repeatedly to each other, that when it comes to this particular area, the chairs will agree to have their committees, their individual committee, be able to ask those questions.
Well, Chair Mariani.
So I'm perfectly fine with the question being asked here. The issue, I guess, is if the committee doesn't want to spend the time doing that, then I think we, to Representative O'Neill's point, we probably would be obligated to ask those questions.
Well, and Chair Mariani, I'm in agreement with you on that. I think that there's a 50% overlap between our committees in the first place, and a lot of members serve on the same ones. And I think the questions can be validly asked in either committee, but I give deference to members to a certain extent too if they do bring it up. And Representative O'Neill, it's your prerogative. I mean, you want to ask a question here, or you really want to think it's, I don't know. I think we should be able to ask the questions here or anywhere, but go ahead and speak to that if you'd like to.
Thank you, Mr. Chair. Well, I think it's a conversation that needs to be had because we're adding a new penalty to law, and I know it doesn't have parity with the theft statutes because there's not a number, an amount that was stolen that equivocates to the crime. So I just wanted to know from the author what was the thought process behind that, and how will you determine what, it's just one penalty. So if you do any of these things, you now have committed a felony with 5 years in prison and $15,000 fine. And the theft statutes is graduated by how much you've stolen, whether it was $500 for either a misdemeanor, I believe it's a misdemeanor, and above 5,000, or excuse me, 500, excuse me, for a misdemeanor, and then, it's graduated up depending on how much you've stolen, and the highest is over 5,000, which is the highest penalty. And this is very, very different than that. And they did reference that this is similar to the theft statutes, and I'm saying it really isn't. And so I think we should have that conversation.
Representative Pinto.
Thank you, Mr. Chair. I should note, so what this is this relates to having kickbacks or bribes. So it's sort of the next level up in a way that it's not saying the theft of the funds themselves or the equivalent of that, right? It's saying that if there's a kickback or bribe, and the thought is that if there is a kickback or bribe, there should not be a kickback or bribe. And if you receive a kickback, you receive a bribe, and then boom, the penalty applies. And so I think that's the thinking for why it'd be different than the graduated penalty, which certainly with a theft, we want to distinguish shoplifting, something small, and then something else. Whereas with this, if you've got this human services program, there's a kickback or bribe in place at all, then that's where it kicks in. And obviously it's a policy judgment, and I could certainly, one could imagine that it might make sense for it to be graduated, but I think that that's the policy rationale for why at least as it's being presented, it's not graduated. It's kind of a different setup.
Representative O'Neill.
Thank you, Mr. Chair. Well, I would suggest that maybe it should be graduated because you basically are, so example, I'm working on something for retail crime, organized retail crime. So you've got somebody that goes in and they have a shopping list and they go in and they steal everything from Home Depot or whatever and they walk out the front door. And they do that day after day after day. Well, that's a very different crime than the little kid that walks in and steals a candy bar. So what I'm getting to is maybe this was a one-time occurrence, or maybe this was really, really organized and it was, $1 million, $2 million, whatever it was, $100 million. So there is no it's just one penalty. It's just a felony, and it's 5 years, and it's $15,000 for the smallest interaction to the most egregious. And so I'm just saying it should be weighted in some way.
Thank you, Mr. Chair. And I actually think, Representative O'Neill, I think that's a terrific point, because you certainly could imagine a small kickback for or something small. We're very concerned about it, but still could be very different, something big. And I'll actually note, you didn't, but actually one other point that's in theft is is as an aggregation clause, right? Because you say you get the bribe on this day versus next week, and then they should be potentially aggregated if you have an amount. So if you're going to go to the amount, maybe that gets added too. So I think that's a great point and something to consider adding as it moves forward. So thank you so much for bringing it up. That's really good.
Thank you, Mr. Chair. I would.
Yeah.
May I continue?
Go ahead, Representative O'Neill.
Thank you, Mr. Chair. So I would really recommend that, because you're talking about scale, right? And definitely do the aggregate, because that's where you get to the scale. And I think that there's a lot of difference. You've got someone, that less than $1,000. I don't know, just pick a number, whatever. A small amount versus this is organized and this is concerted effort. So I just think it should be scaled, just like our theft statutes are scaled. Thank you. That's all.
Thank you, Mr. Chair. We may need to hire Representative O'Neill at our county attorney's office, because she's clearly she's thinking like a prosecutor in many occasions. So thank you.
Chair Lieber.
Yeah, thank you, Mr. Chair, and I thank you, Representative O'Neill. I also have some concerns about this, and I'll talk with the author offline, but I did just want to thank Representative Pinto for working on this, and Mr. Johnson. I mean, fraud is not a new thing. Anytime you have big public programs, you're going to have fraud, and we constantly have to try to keep up and tighten up our laws and figure out how to root it out and find it, and that's something that we all have interest in. And so I appreciate this, Representative Pinto. I know you're going to continue to work on. I know this is going to come to my committee as well, so thank you very much for bringing this.
Last comment, Chair Scott.
Thank you, Mr. Chair. And if one comment that I didn't make but wanted to, and if we're going to kind of broaden the scope of the conversation, on 12.7 through 12.11, it's talking about suspending a vendor's participation in the program if they've been convicted of a crime, et cetera, and my recommendation there is if you're convicted of a crime in this area, I'm sorry, but you never get to do this again. You don't get a license back. You don't get to participate in this program anymore. So those are just my thoughts, Mr. Chair.
Thank you. I'd offer closing comments, Representative Pinto, but we're already 13 minutes past our closing time.
Thank you so much, Mr. Chair and members.
The motion was made by Representative Hassan, made the motion that House File 2319 be recommended to be re-referred to the Ways and Means Committee. All in favor say aye. Aye. All opposed say no. Motion passes. You're on your way. Thank you, Representative Pinto.
Thank you, Mr. Chair, members.
Members, we're planning to cancel the Tuesday and Wednesday, 26th and 27th meetings next week, and we're only going to meet on Thursday, the 28th. But we're going to go long on Thursday until 12:30 in order to finish up business prior to second deadline. How's that sound? Yeah, so clear your calendars to 12:30 on Thursday.
No coffee.
Wait.
Yeah.
Wait, Thursday.
And then we've got up tomorrow, we've got Representative Mahler, Representative Sandsteed, Representative Davids, and Representative Tabke. That's it. There being no other business before the committee, committee is adjourned.